Welcome to our Regulations video series. I'm Laura, your Customer Success Manager, here to guide you through the Connecticut Data Privacy Act and its key requirements. The law empowers residents with privacy rights and sets responsibilities for businesses. In 2025, new amendments updated profiling, sensitive data, and minors' protections, alongside the cure period sunset. Taking effect on July 1, 2026, these amendments have drastically lowered compliance thresholds, expanded protections for minors, and introduced new transparency rules for AI training. The CTDPA was signed into law on May 10, 2022, and became enforceable on July 1, 2023. On January 1, 2025, opt-out preference signals took effect and the cure period ended. In June 2025, amendments were signed into law, effective from July 1, 2026. Effective July 2026, the law applies to companies operating in Connecticut or targeting its residents that meet any of these three new criteria, processing the data of 35,000 or more consumers annually, processing any amount of sensitive data, or offering any personal data for sale. Exemptions include government entities, nonprofits, higher education institutions, and organizations covered by federal laws such as the Health Insurance Portability and Accountability Act, the Gramm-Leach-Bliley Act, and the Children's Online Privacy Protection Act. Employment and publicly available data are also excluded. As of 2026, tribal governments, insurers, air carriers, and SEC-regulated broker-dealers are also exempt. Businesses must provide clear privacy notices that now disclose if data is used to train large language models and opt-out options, obtain consent before processing or selling sensitive data, and require opt-in consent for targeted ads and data sales for anyone under 18. Consumers can opt out of any automated decision with significant effects. Revoking consent must be easy, and data use must stop within 15 days. Website owners must provide at least one secure request channel and respond to requests within 45 days, with one possible extension. Appeals must be resolved within 60 days with written reasoning and Attorney General contact details included. Privacy notices must be easily accessible and clearly display the month and year they were last updated. Companies must conduct data protection assessments for high-risk processing, honor browser-based opt-out signals starting January 2025, and handle loyalty program conflicts by honoring signals while notifying consumers. Consumers have rights to access, correct, delete, and port their data, as well as opt out of targeted ads, sales, and profiling. Under the 2026 rules, they can also request a specific list of third parties who bought their data and actively challenge automated profiling decisions. The Attorney General enforces the law, with the cure period having ended on January 1, 2025. Violations may result in penalties of up to $5,000 per violation, with no private right of action. Thank you for joining us. At Climb, we're here to help you navigate compliance with ease. Visit us at climb.io to learn more about our all-in-one digital compliance solution.